Senator Lee.
Thank you, Mr. Chairman. Thanks to all of you for being here. We've got a really good panel today. I've interacted and known many of you for years. It's a pleasure to have you here. Professor Bray, let's start with you. In his dissent in Trump versus Hawaii, Justice Thomas explained that if district courts have any authority to issue universal injunctions, that authority has to come either from statute or from the Constitution. Have you identified in your research any provision of the Constitution that authorizes a district court to issue a nationwide injunction?
No, and in fact, I think it's inconsistent with the case or controversy requirement of the Constitution.
And have you found any statute that does that?
Again, I think the answer is no, though I should say just a little more about that. The Judiciary Act of 1789, which is the Charter of Federal Judicial Power, has been interpreted by the Supreme Court to mean traditional equity powers. This is not a traditional power of equity.
Right.
And so I don't think there is, though there is, of course, debate on this panel about the APA.
In fact, if we had Professor Blackstone, Judge Blackstone in front of us, and we asked him whether this would be an appropriate use of injunctive power, I would imagine he would be scratching his head a little bit.
He would be entirely nonplussed under his wig.
Yeah. Professor Bagley, I want to make sure I understand your position. You said a moment ago that you would support the idea of Congress clarifying this standard. Is that right?
I mean, it always is hard. I mean, in the abstract, sure, but I'd want to know what the legislation looked like.
Right. A few minutes earlier, you said, called into question whether Congress is nimble enough to do it, and that's a very fair observation. We're not exactly known for our precision. And yet it certainly wouldn't be outside of our authority to do that.
No, not at all.
Given our authority to, in fact, ultimately for many of the reasons you've identified, if we don't do it, it may be years, if not decades, possibly before the courts act. We have no guarantee that the courts will do anything. We know that we can.
That's right.
Are you familiar with the legislation that's been introduced by Senator Tillis in the Senate?
I am.
Is there anything about that you think would be problematic? I mean,
No.
Basically it just says courts shouldn't issue injunctions that are neither applicable to just the parties before the court or within the district in question.
Yeah, I think the important and the key for me in thinking through this problem is to focus the relief on the plaintiffs. And as I said earlier, that relief can often extend well beyond the geographic scope of the district court, just as in Senator Whitehouse's question about the upstream polluters. So once you have that picture in view, I don't see any reason to arm the courts with this discretionary power that goes far beyond the authority they've wielded traditionally in our system.
And you're not troubled by the idea that a third party might benefit in some way from an injunction. You're just saying that injunction shouldn't be binding on parties not subject to the litigation.
Right. The courts should focus their energies on addressing the irreparable injuries and the injuries generally of the parties who appear before them, and they shouldn't extend their work to questions that I think are better handled by the national legislature.
And in that sense, one really can't argue that it's outside the scope of the court's jurisdiction to do that. It's outside the scope of their Article 3 jurisdiction to act.
I have, I think, a little more of a flexible understanding of what Article 3 might allow, in part to enable you to craft legislation that would address whatever current problems you believed were. So if the Congress were to pass a law empowering courts to enter nationwide relief, I'm not sure I'd have a constitutional problem with that. I would have serious policy objections.
Mr. Panuccio, I loved your description of the fact that ultimately Congress is to blame for this. And in fact, we are. Over the last 80 years, we have taken power away from where it previously resided in two steps. First, moving power in rather broad swaths from the states and local governments in America and moving it to Washington. Within Washington, we've moved it from the people's elected lawmakers in Congress and handed it over to unelected, unaccountable bureaucrats. Men and women who, while well-educated, well-intentioned, highly specialized, and hardworking, don't work for the people. They can't be fired by the people. They don't really even answer to anyone who is, in turn, elected by the people. And in the process of doing that, Congress, having accumulated, arrogating to itself so much power that it previously didn't have, has seen fit not to enact legislation, but in many cases platitudinal statements. We shall have good law in Area X. We hereby delegate to commission or department or division Y the power to make, interpret, and enforce rules carrying the force of generally applicable law. But that then is subject to change by those same bureaucrats. Explain to us again how that dynamic, Congress delegating and outsourcing the lawmaking task, inevitably culminates, absent action by us, in the type of judicial overreach that you're describing. In other words, we've heard this described as executive overreach that causes it. We've also heard it described on occasion as judicial overreach. In a sense, isn't this all the product of legislative underreach? And if so, explain how that works.
Well, Senator, thank you. I think that's a very apt description of what has happened as the administrative state has grown in ways that the original Constitution could have never contemplated. The checks and balances that the framers put into that original Constitution no longer apply. And so what you have is this situation where the administrative state, the executive agencies are essentially making law that was supposed to be made in Congress with all of those protections. And then aggrieved parties are trying to find ways, and courts are trying to find ways to have a check on that administrative process. And you end up getting one constitutional derogation creating another, courts doing things that the Constitution never contemplated. And what we're talking about today, what Senator Whitehouse was proposing here, it's starting to sound more and more like the courts acting as councils of revision. And that was something that the framers thought about. It was proposed by James Wilson and others. It was hotly debated, and it was rejected because that's not what the judicial power was thought to be by the framers. So the more we get away from the idea that Congress legislates and not the executive branch, the more we try to find these other ways for the third branch to provide some check on that power.
And if I could just close out that thought, Mr. Chairman, typically you would not see a court enjoining Congress from making a particular rule. That would seem to violate a certain separation of powers principles. And so that's one of the reasons why when we delegate to an unelected, unaccountable agency the power to make and interpret and enforce laws, that inevitably culminates in this sort of action. So, while I do fault courts that abuse their injunctive authority in this way, it's entirely foreseeable, and in some ways it's a problem that was willfully created by Congress when deciding not to act. As Geddy Lee with Rush wrote, if you choose not to decide, you still have made a choice. Here we've made a choice over the last 80 years, and that's resulted inevitably in nationwide injunctions. Thank you.
Senator